Fatoki, Dr. Yewande Fatoki. I saw you come online earlier, and I want to believe you are still online. And Dr. Yewande Fatoki will,
yes, I am.
all right, will be talking to us about the role of forensic evidence in securing convictions, a comparative study of adversarial and inquisitorial legal systems. Yewande Fatoki is a lecturer at the Lead City University, Ibadan, and she is also a fellow of the Forensic Investigators Society, Nigeria. Over to you, Dr. Fatoki.
Good morning, everybody. I am responding on the existing protocol. Thank you so much for the opportunity given to be here, even though it's virtually, but I appreciate the opportunity given. Can you hear me, please? Hello?
Yes, we can hear you.
Can hear you,
We
ma'am.
can hear you.
Oh, okay.
Right.
Oh, okay. Thank you. So, well, I'll be presenting on my paper is on the role of forensic evidence in securing convictions, a comparative study of adversarial and inquisitorial legal systems. So, well, I'll start by saying that though a lot has been said about forensic evidence, forensic experts, a lot has been said about that.
Yewande, please.
But
Dr. Yewande, my apologies
hello, yes,
for stopping you. But like I usually say, when you're presenting in an enclosed place, there's a tendency for you to give us the bedroom voice. So you're gradually giving us the bedroom voice, but we need the lecturer's voice to come out. So please, ma'am.
Oh, okay. I'm hearing that for the first time.
Thank you so much, ma'am.
I'm hearing that for the first time. Okay, but I'm just talking the way I talk normally. So, but okay. So, as I was saying, so talking about forensic science, of course, we know that forensic science, when it comes to, I'm sorry, let me start with forensic evidence. Forensic evidence actually has a great role that it has played, in transforming criminal investigations. It has helped in transforming criminal trials, and the reason for this is because of the way it has helped in providing objective scientific insights, and which has in various ways now complemented traditional testimonial and kind of circumstantial evidence, when during trial proceedings in courts. And this forensic evidence, of course, there's no how we cannot do without it, especially number of cases when it comes to criminal trials. There is no how we can exclude it in number of cases when it comes to criminal trials, and because as a result of that, it has been used, being operational in different jurisdictions, different legal systems, including those that are adversarial and those that are inquisitorial in nature. And the reason why where I'm doing a comparative analysis of the adversarial legal system and inquisitorial legal system when it comes to securing rule of forensic evidence and securing convictions, because the two systems are different. And for example, Nigeria here, we operate the adversarial legal system. Nigeria, the UK, the United States, and some other countries, we operate the adversarial system, whereas the inquisitorial systems now is employed by some other countries such as France and Germany. And when we talk about adversarial systems, we are talking about this system where the judge is the person that acts as an arbiter. The judge or the jury, in the case of the United States, they sit down, they count the prosecutor, the defense counsel, they come before the judge to give evidence, to cross-examine, to examine, and to re-examine witnesses, experts, and also these forensic experts when it comes to criminal trials. So the prosecution, the defense, they will present their evidence before the court, and the judge will not be the one to decide at the end of the day. But when it comes to inquisitorial, it is usually a kind of pre-trial before the main trial. That is when investigation, forensic experts are invited to come and investigate, to come and look into the matter to see that, okay, should we bring this person to court to come and answer? this case, or should the person be excluded? Is this person innocent, or this person will be excluded from coming to give evidence? So in a way, and when you look at it, for example, the adversarial system now, when you look at it, it has its advantages, it has its challenges. And one of the advantages is that it allows forensic experts to be challenged openly in court. That is when cross-examination came in. I think the last speaker, or the person before the last speaker, spoke about cross-examination, the importance, because when he was giving his lecture, I heard him saying some things about cross-examination and the importance of cross-examination and how it is expected for a lawyer to be very good, so that he will be able to cross-examine properly, especially when it comes to issues of cross-examining experts. And even as an expert who has to be prepared going to court, because they should expect that he will be cross-examined as well. So he should be prepared. So adversarial system now, like I was saying, is that the judge will be the one that will sit. The judge will determine. The system is just to protect the accused person. That's what the system is about. The adversarial system is to protect the accused person from wrongful conviction. And how is this possible? It's by ensuring that the prosecution's evidence is open to cross-examination, so that you're coming to protect, okay, this is it. You're coming in the expert. That will be cross-examined to actually know that, okay, he has done the necessary things. He has carried out the necessary tests. He's sure of what it's saying. He knows about this forensic evidence that is presented. And he will also be cross-examined over and over, so as just to ensure that, okay, we are not going to convict a wrong person based on the testimony of these experts, based on this testimony of these experts. But the truth is, it's not without its challenges. Another benefit of the adversarial system when it comes to forensic evidence being given an adversarial legal system is that it provides opportunities, like I said, both sides, they'll be able to present their alternative forensic interpretations. So you come with your own experts, I come with my own experts. And then the challenge now begins in open court. But like I said, it's not without its own challenges. And part of its challenges is the fact that forensic evidence at times, the way it's contested, it can be heavily contested. And this will now lead to varying standards of admissibility. Because each expert coming now is coming to testify based on, in line with his own interests. So if I'm coming in as the prosecution witness, forensic expert witness now, of course, my testimony will be to favor the prosecution. If I'm coming in as the defense counsel, forensic expert witness now, it will be to favor the evidence of the defense counsel. So that standards of admissibility is usually heavily contested, and which can cause a kind of variance in it. But then at the end of the day, it's still left to the judge to decide. And then another thing is that this expert testimony, the forensic expert testimony now becomes a kind of battleground. Each person wants to win by force. Whether even as a result of that, conflicting interpretation of the evidence might not be presented. So that is not unlikely. And then another challenge is that even though we are saying that it is used necessary to prevent wrongful convictions, but there are actually times, especially in a country like Nigeria. Was it yesterday? Yes, because that's one of our presenters. Can't remember now if that was the keynote speaker. That was talking about the forensic laboratory that we have. That it's so sad. I think the only one we had was in Lagos, and even now it's not even functional. So that's even so sad. And we have a lot of cases that go to court. They should have gone through for these labs, to determine, forensic tests and all those things. But unfortunately, these things are not exactly like that when it comes to Nigeria. So how many times we even carry out this? So at the end of the day, you still see that wrongful convictions are still, not reduced. So you still have people who are still wrongfully convicted, just because either based on the experts' evidence, forensic experts' evidence, or because we don't have the resources to even carry out all these necessary tests, to actually ensure that, to determine the culpability of the defendants, of the accused person. And then I'm going to the inquisitorial part of it. Like I said, inquisitorial. Hello, can you hear me? Hello?
Yes, we can hear you, ma'am.
Oh, okay. I thought I lost everyone. So as I was saying, looking at the inquisitorial system now, the inquisitorial legal system, yeah, look at countries like France and Germany, actually, yeah, they operate the inquisitorial system of legal system. And what happens here is that the judge is usually referred to as investigative judge, or there is an investigative judge. And this investigative judge, he plays a very important role. And the role he plays is that he has to engage in collecting and also be part of those that will evaluate the forensic evidence during the pretrial phase. That means during the main trial, the actual trial proceedings. So this it's usually before, whereas as the adversarial is within during the trial process. But when it comes to inquisitorial, it is before. That is the inquire before the actual trial. So they engage in collecting and evaluating forensic evidence before pretrial phase or before pretrial stage of the matter. And the reason is that when you look at this process, one thing that it does is that it ensures that forensic evidence is assessed impartially, before the matter is actually brought. In fact, to determine whether the accused person or the defendant will even be brought before the court if he has a case to answer. So they will have determined right before the actual trial that, okay, after going through all the forensic evidence, calling experts to come and evaluate, to come and investigate, they now look at it and consider, oh, maybe should this person proceed to trial? Or no, this person is innocent, he cannot proceed to trial, and then the person is excused from there. Whereas our own system, the person gets to court before expert witnesses are now, before the forensic expert witnesses are now called to come and testify as to or against the person. So like I said, for example, in Germany now, Germany operates an inquisitorial legal system, and here the forensic experts are actively involved in the pretrial investigations. They are part of it. When investigation is going on, they are getting ready. They are highly involved in it, going through different whatever it is that needs to be tested, that needs to be taken to the laboratory right from the beginning. They are part of it. They are part of it. And one good thing about this is that both the forensic evidence experts and the law enforcement agencies, they are able to work together. It encourages a kind of close collaboration. So as the police, let's say for example, are investigating, the forensic experts, whether in the department or whoever it is coming from outside, we work together with them. And it's usually increases accuracy of evidence, because you know that before you can bring somebody before the courts now, that means it has been seen that this person actually, from all tests carried out, DNA, toxicology tests, stuff like that, it's actually seen that no, this person, if this person gets to court, it's because we have enough, forensic evidence against this person to show that he actually committed the offense. So the judge has more power here. The judge has more power, like I said, because the judge too is involved in that investigative, is also involved at that particular time. He has more power, and he has extensive pretrial investigations and questioning. He can ask questions at that particular time, you know, just to so that's why the judge is referred to as the investigative judge as well. He too makes inquiries, as to the matter. And like I said, it is to avoid bringing an innocent person to trial. That is it. Whereas in our own system, that person, whether innocent or guilty, would have first of all been put to trial before, it would be brought to court before forensic expert witnesses are now called to come and look into the matter. And this inquisitorial system is not without its own challenges too. Even though it reduces issues of disputes in court, by the time the accused person or the defendant gets to court, it's because they have enough evidence against him to show that he actually committed or is part of those that committed the crime. They have so it reduces the disputes, arguments, the way it would have been in adversarial system, where the defense counsel will come oppose, prosecution will raise their own defense, the back and forth of questioning, cross-examination. But when it comes to the inquisitorial, that aspect has been, excluded because it has already been done during the investigative stage before the matter even gets to court. So, and also the judges too are always in a position to see the application of scientific methods. The way the tests are being carried out, whatever test it is that, let's say the judges are involved in the whole process. So they say if it's whatever it is going on in the library, in the laboratory, to see that, okay, maybe to take fingerprints, the judge is already part of it, is involved. He says, oh, okay, they are taking the fingerprints of this person. Oh, it's actually this person's fingerprint. So this person, so it's kind of reduces the work for everybody. It reduces the work for everybody. But also, it's also not without its own challenges as well. And part of the challenges is that it's even though it's easy. It's kind of more straightforward than the adversarial system when it comes to forensic evidence, yeah, giving forensic evidence. The truth is that it's for lawyers for those who like going to court, to argue, who enjoy it, that is kind of, it has its own limitation that has been taken away from it. So this courtroom disputes, this courtroom arguments, by one counsel against the other counsel is reduced. That doesn't really happen when it comes to in the inquisitorial system. And so it might not, somebody that likes going to court to actually argue might not actually, really enjoy this. Then another thing is that the role of the judge too, the role the judge plays as the evidence evaluator, as the main decision maker too, you know, if care is not taken, it might be still kind of impartial, whatever, can still, creep in as well. Especially when the matter is high stake, when the matter is going to be high profile. We all know, like, especially when politics. I'm not saying the adversarial system too is not involved in that. There are times when judges are also biased, even when they are given their decision, irrespective of the facts of the evidence that has been placed before them. So the same thing also happens when it comes into tutorial system as well. So it doesn't matter that, okay, the judge has been part of the evaluation right from the beginning, or part of the, going with them to the lab, part of the investigative thing. But at the same time, too, there is also the possibility of impartiality, also coming in from or seeping in through the judge. Then another thing again, and because these at times also leads to reliance on judicial discretion. And when you now rely on judicial discretion alone, that can actually also lead to partiality. It can also lead to inadequate scrutiny because you might just so that, oh, the judge was there now, the judge saw it, the judge was part of the evaluation thing, and you just believe that, oh, okay, so that means whatever they are bringing down to the courts, that's it. It's fair. It's non-partial. Whereas, they might have done some whatever it is before. That is, and I like what I think the last speaker also said, that when it comes to giving forensic evidence, that it should not just be the responsibility of one person, that it should be shared so as to reduce corruption, so as to reduce issue of bias. By the time it's given, like each person is assigned the responsibility, it would limit the level of corruption, it will limit the level of partiality, it will limit it. But if it's just assigned to one person and one person has the whole responsibility, then the person can we just be like, we'll be able to act as the alpha and omega of that particular. So then another challenge is that there are times that when it comes to this the I'm talking about the adversarial also. I remember another thing that I wanted to say is that there are times that potential biases and errors in forensic analysis are overlooked. They're overlooked, and it shouldn't be that. It shouldn't be like that. So generally, the truth, when you look at it, in fact, when I was reading up for this presentation, I looked at it, I was like, okay, both in inquisitorial system and the adversarial system, yeah, both systems are good. We are not saying that Nigeria should imbibe the inquisitorial system. We already have our own legal system, which is working for us. And even if you want to now imbibe the inquisitorial system, do we have the capacity? Do we have the resources? Do we have what it takes, to engage in that? Because even with our adversarial, thank God that we have experts who we can even call to come and give evidence in court. If it's just limited to the resources we have, it might kind of be difficult. Because even the forensic lab that we have is not functioning, it's not working. It's not functioning, it's not working. So, that's kind of like a limitation in its own sense. But aside that too, like I still feel that our system adversary is still better because by the time you call The defense calls its own experts, the prosecution calls its own experts, they're able to weigh their evidence and say. And by the time you look at it, in fact, the courts too, of course, the judge is now also allowed to also, it's not as if the decision will be given immediately. No, decision will not be given immediately. So that's why even after checking, weighing the evidence of coming from both sides, the judge so sits down to determine if we do his own actually giving the court, and would also base his decision on that. So the truth is generally forensic evidence has its general um, challenges, especially here in Nigeria. When we look at times, we look at the reliability of the forensic method employed in coming to. So it's not all our, and I think even in some advanced, maybe at maybe the level now, I'm not. I'm a lawyer. I'm not a forensic expert, but I just, but I know that there are times that they are no accurate. There are no the forensic techniques are not at times scientifically validated adequately as they should be. They are not like there are times they are not 100% accurate. So we still have that challenge. So which makes reliability on forensic methods, to also give us certain errors at times because then some of them are not 100% accurate. They're not. Then we also have bias and misuse, which is a general challenge. So there are times that these forensic experts might come forward and, in the course of giving their evidence, they introduce bias. And by the time they introduce their bias, their findings at the end of the day will be misinterpreted by the courts, which is also, a challenge generally to forensic evidence. Then we have the issue of training deficits, especially here in our country, Nigeria. Even though we have experts, but how well trained are they? How often are they sent out to, for training? Are they? Thank God for what forensic investigators society is doing. This is like, I know that in April we had the training as well, the workshop, and this has really, even for me, it has really opened my eyes to quite a number of things and also helped me. I beg my. Hello.
Dr. Yewande,
Okay.
you went off at some point,
Oh oh
just
oh
few
oh.
seconds ago, just few
So,
seconds.
so I was just talking to myself. Sorry about that. Should be the network. So as I don't even know, but let me just continue. Talking about the challenges facing forensic evidence generally, and I'm been referring to actually the issues that we have here in Nigeria. So as I was saying, I said even though we have forensic experts, but there are times it's just that they don't have adequate training. But I now say that I appreciate the efforts of the Forensic Investigators Society, which I appreciate what they are doing, trainings, workshops, conferences like this, to give help us to provide insights to educate us more on forensic science, forensic evidence, forensic expert witnesses, all these things. But aside that too, it's not just the forensic experts that needs more training. Even legal professionals, people like us too, lawyers, we need more training too. Even judges too, because a number of lawyers, legal professionals, not because it's not just limited to legal professionals and judges, they lack adequate training when it comes to critically on and assessing forensic evidence. So it's just, some might listen to what they say in court, or some lawyers might not even do their own research. They just come ask questions and they don't even understand what they're asking or what the expert is even saying. So that's also a disadvantage. So we need training even. So I think more, even me, I've told myself that I'll try as much as possible. When conferences and workshops like this are coming up, that I would, circulate it among lawyers as well to encourage them to be part of it, to join the conference, to join the training, so that they also learn. And by the time we go back to court, we're better persons than before, especially when it comes to forensic, giving, assessing or cross-examining forensic experts or assessing forensic evidence. That will also help us. Then another big major issue that we have in Nigeria when it comes to issue of forensic evidence or calling forensic experts is the issue of finance resources. We have resource issue, lack of resources. That's a major issue. Nigeria is a developed country, we know. Do we have adequate forensic technology? Do we have yes, advanced forensic technology? Do we have it? I don't think so. Even when it comes to issue of DNA, I know it's usually majorly it's all these private hospitals. What's the government doing, about this? Thank God for the few private sectors that we have that are helping with some of these things. But otherwise, the government has a major role to play too. So that's some of the problems. So looking at it in all, I would just say that the even though the effectiveness of forensic evidence has been undermined by procedural disparities. That is simply saying that just because of the procedural differences in legal systems, differences and level of understanding when it comes to listening to assessing and examining forensic evidence and assessing forensic experts, there's kind of the effectiveness, it's kind of limited. The understanding is kind of limited. So amongst a lot of lawyers, amongst a lot of judges. And we can't exactly blame them, but it's just because we do not have adequate resources. We do not have enough training. We do not have enough, That does not mean that forensic expert evidence have not been useful. It have actually been useful both in inquisitorial legal systems and also within the adversarial legal systems too. It has actually been very, very helpful. Otherwise, fine, we say we have a lot of wrongfully convicted people in correctional centers and prisons. Otherwise, probably they will have been much more than that. And a lot of people too have also been, exonerated, found innocent based on forensic evidence given by forensic experts, witnesses who have come to court. And like it's always said when it comes to law, it's better for one accused person, one guilty person to walk away than for 10 innocent persons to be jailed. So even if we are looking at the probability, oh sorry, the ratio that we still have a lot of people in prison, but then we can still say that it has helped in setting a lot of innocent people free and granting them their freedom. But then we still have to make recommendations as well. There's still room for improvement. Like I said, we have unreliable forensic methods, we have bias and misuse, we have training deficits, resources are not adequately provided for. We don't have good resources, even human resources, not to not talk of the advanced technology and forensic technology that we actually need in a country like Nigeria. There's still room for improvements. It should start with the government, I would say. I would say that it should start with the government. The government has a real role to play. They have a very, very huge role to play. It should not just be limited to, even though individuals too, we have our role to play. Thank God Forensic Investigator Society is doing that for us by promoting training, by encouraging workshops, by encouraging creating awareness, even involving students, grooming them from the start, from the beginning. It's not just limited to classroom teachings done for students, but they are part of this too. They listen to experts who have come to, to lectures and to, yes. So that is important. Then another thing again is that I would say there should be a clear guideline. There should be a clear guideline for admitting forensic evidence. Even across jurisdictions and also even here in Nigeria, if you look at our Evidence Act, like, okay, I thought I even looked at some of the sections. I think even though it's just some years ago, it was kind of amended, but I think we still need much more, especially now that the world is getting digitalized and everything is technology based now. You look at AI, and everything. So I think there should be room for improvements when it comes to our legal frameworks as well, which will, or even pending the time when these are even enacted into laws, there should be set guidelines, to help for a better way of admitting forensic evidence in courts to improve assessing forensic evidence that has been given by forensic experts, across jurisdictions. And like I said, too, training is important to equip lawyers, to equip judges, to also even equip forensic experts, especially in Nigeria. You know, bring in more advanced experts to train them. Let them also go out, to jurisdictions where we have these instruments. There are some people that don't even know how to handle, how to even access, how to even make use of. How many places do we get to that they have lie detectors here in Nigeria? It's not as if I'm not saying that it's 100% accurate, but to some extent, it has its own role, its own, you know, it plays its own part as well, when it comes to evidence giving and even knowing whether an accused person or whether somebody is saying the truth, although it's not accurate, but it's still better, it's still okay. Then also, collaboration should be encouraged, interdisciplinary collaboration. And I don't know why I keep referring to forensic investigation society. The truth is I actually like what they are doing. Giving room for, I say, immigration heads have been here to talk, police heads have been here to talk, lawyers. I was even glad when our anchor person said we have a police officer who is also a professor in our midst. This collaboration, interdisciplinary collaboration too, will go a long way, in promoting and enhancing forensic evidence, promote enhancing the presentation of forensic evidence, to also help. Then also independent forensic bodies should be encouraged as well, should be encouraged. And when we have independent bodies, that to some extent will reduce the risk of bias. It will reduce the risk of, it will ensure that we have objective analysis so that we have the independent body. We also have the governmental body as well. So they work hand in hand, even though they are working separately. But you know that, okay, if this particular body, if you suspect a kind of bias, then you can also move to like, okay, let us go and check it out there and make comparison. That's it. But when it's just limited to just a particular body, let's say it's only the government that is in control, there will be a problem. And if it's only just the private body that was in control, there will also be a problem. Let us even look at it. The issue of finances, how many people can even afford, especially when it comes. Let us look DNA, that is the simplest of all. You know how much they do it, especially with these private sectors. But let's say the government steps in now, yeah, maybe the price they cost to be subsidized for the citizens. So that's also part of it. So I think then also okay, I've talked about collaboration, which also includes global cooperation as well. We should look at it. Okay, what are those things that are being developed? Bring in new technologies and also introduce new technologies here in our own system. Nigeria, yes, we are good, we thank God, but we still have a long way to go when it comes to forensic evidence. There are a number of cases I've witnessed some that they should actually, the forensic experts are expected to have been called to come and give evidence. But at the end of the day, no expert is being called. It's expected that every law enforcement agency has their own forensic units. I know the police work they have, but then how efficient are they? How efficient are they? Let us forget about, okay, maybe their headquarters where they have it all. But all these other police officers, all these other police, what comes to give evidence. Some of them come, they don't even have the, and even the way they even so and looking at it, let's say for example, person goes to a crime scene, getting to a crime scene, maybe one of the things used there, let's say a gun. Some people do not even know how they're supposed to handle it or take it from the crime scene, something that has been, contaminated, you still bring it. Even when there is no forensic lab that you take it to that will give adequate, so it should start from all this. So training is needed over and over and over. We should not say, oh, I know about it, I understand it, I'm okay, I'm an expert, but you keep learning and relearning and learning and relearning because the world is evolving every day. Technology is advancing every day. We should not just sit down and say, okay, this is it. We should not limit ourselves. And I would just also want to encourage the government and those of us that are close to the government, please, we have to do something about our forensic lab. It is very important. It is very important. The one that is available, they should make it functional and also now safe, to have more. If you have uh, good forensic laboratories in each geographical zone, it go a long way. But by the time we have just one that is manageably functional in Lagos, so they are bringing from Abuja, they send to Lagos from Kano, they were sent to Lagos from, it's kind of even slow down trials. It will slow down trials. It will have its negative effects also. It will delay justice. To delay justice. And one of the things that forensic evidence is supposed to do for is also to promote justice, speedy administration of criminal justice. It should promote it. There should not be any form of delay. So I think I will stop here for now. Thank you very much for your time. Thank you for listening. And I would be waiting to entertain any question.